Today we're going to start with good news. I got 2 emails today, just now, about an hour ago, that they got their green cards. These are the people who filed in October of 2020. It's always good to hear that from the clients calling or dropping an email. My green card is approved. It's the most happiest thing that can ever happen to me, particularly. And of course, our whole team, Emily, and all our team in our office. Emily, we're going to start with the speeding tickets today. You know, a lot of people are concerned what's going to happen with the speeding tickets, and we're going to discuss about if the final action date is current, when am I going to get the green card. We're going to discuss about the H1B cap. Will there be a second lottery? We're going to discuss about the F1 students who are anticipating in getting the visa stamping and coming into the United States. And we are also going to discuss about EB2 to EB3. There is something called ability to pay. We want you to understand what that is. When you're making the decision, you probably need to know that. Very good. Emily, speeding tickets. Oh, I got a ticket. I paid $200. Fine. Do I need to report in the 485 application? A lot of people are saying yes, no. What is the issue though?
Yeah, the run-of-the-mill speeding ticket is not considered an arrest that you need to disclose. The actual 485 form instructions confirm that, and they tell you that you do not need to disclose certain speeding tickets on there. If there's any kind of DUI involved or any kind of injury, that may be a different topic. What are your thoughts on that?
This is on the page number 13 of the 42 page of the I-485 instructions. There are 42 pages for you to read into the instruction. We just want to boil it down to one thing. If it's less than $500, it's just a traffic ticket, no DUI involved in it, no arrest involved in it, you do not have to mention. And I strongly recommend, if you fall into this category, do not mention, because once you say that you've been charged with any crime though, then it goes into most of the time you will be interviewed. That's a big problem though. So we do see that some of the lawyers do answer yes to that question. We strongly recommend you do not answer yes if the traffic ticket is less than $500 and it's not a DUI and it is not involved any bodily injury. Just answer no to the question. If anybody has any doubts in it, I want you to go read the page number 13 of the 42 pages of the I-485 instructions. It clearly says you do not have to disclose it. So if you get into trouble, you can always print out the information provided by the USCIS. There you go. The instruction said not to disclose it. I did not disclose it. You cannot penalize me for following your instructions on your website and on your form. So if you guys have patience, go look at that one. Emily, on the final action dates, if my final action date is current, I am still not getting the green card, or when would I get the green card?
Yeah, you know, there's so many moving parts in this process that just having the final action date current doesn't mean that you're going to be able to get the green card in that month. We also have to look at, when did you file the 485? Is it considered within normal processing time, or is it way before the normal processing times? We need processing time. Your case should be current. Final action date should be current. Your biometrics should be done. Your I-140 should be approved. All of those things have to happen before you can actually receive the green card, and and the medical exam should be submitted. So some of those things are in your hand, some of them are not. We can't force USCIS to issue the biometrics notice. We can't force them at this moment to increase the speed of their processing of these applications. They're listing 33 some odd months, and you can't follow up until it's been pending for 3 years. But they are processing faster than that. As Rahul said, we're starting to see approvals. We've been seeing approvals for applications filed in October of 2020, and now we're in June. So that's not bad of processing time, but you need your I-140 to be approved. So if you filed an I-140 downgrade or concurrently with the I-485 last October, you can consider upgrading that to premium processing to make sure that gets over with. If you didn't submit your medical at the time of filing the 485, you can consider interfiling the medical exam now rather than waiting for an RFE. We have instructions, an article on rnlawgroup.com about how to do that interfiling of the medical exam. Other than that, you have to wait for biometrics and you've got to wait for processing time. And you just kind of have to wait until they get around to your application.
As Emily pointed out, there were 4 things that need to happen. The priority date need to be current. That is not in your hand. If it's current. Final action date when I say priority date. The second one is that the biometrics have to happen. That's not in your hand. So when they request it, we can't force them to request it. The third thing is that the medicals have to be submitted. If you have not submitted, there is a link that we have provided to you. You can use that to submit the interfiling of the medicals. Please do not call us, do not email us, just for the medical interfiling. It's already there, the link is provided. Now some lawyers are recommending they should, some lawyers are recommending they should not. It's up to you whom to believe, whom not to believe. Some of the lawyers are concerned. We at our Reddy Neumann PC, we don't care about your $200, $300. If you get a green card 6 months or 1 year earlier, we feel more happy. We are not trying to save you $300 or $500. That's not our motive. If that's our motive, we'll tell you differently. The fourth thing that need to be done is an I-140 has to be approved. If all these 4 conditions meet, then you're eligible to get the green card, but you're not entitled for forcing the USCIS. You don't have a right to force them to approve the green card because the processing time has not passed. According to the USCIS website, which you can see that the processing time is 33 months, but if all 4 of these requirements are met, most of the people will be getting very soon the green card. You mostly don't have to wait for the 33 months. Anything else, Emily, before?
Yeah, I also want to add, we've been noticing that most 485 applications are pending at the National Benefit Center, that's the MSC, also Nebraska Service Center, LIN, and Texas Service Center, SRC. However, when they're processing these 485s, we've actually been seeing them sent to the local offices, and the local offices are the ones sending the RFE for the medical, sending the RFE for an issue with birth certificate, asking for affidavits and secondary evidence. So they are definitely trying to spread out the volume of work to speed up the processing time. We have an RFE that came from the Chicago field office, another one that came from the Harlingen field office just in the last week. These offices are not normally the ones that send an RFE on the 485. That's usually done by the service center, and then the process continues. So hopefully we'll see some speed up.
Emily, and the Harlingen, is that client belongs to the Harlingen 485? Okay,
No.
Can you explain what?
Yeah, this client is in Houston, and so Houston has its own local field office. So we would expect if there's going to be an interview and any RFE sent, it would be coming from the Houston field office. But this file was transferred all the way to Harlingen, which is nowhere near Houston, and we got the RFE from Harlingen. We have to submit the documents back to that field office.
It's actually good news that you guys are getting these RFEs because it will definitely entail these things to be processed faster. Previously, I told that most of the people are, almost none of the people are getting the interviews. I take back that word. Recently, we have noticed people getting interviews for 485. Still, I think so great number of the people are not getting their 485 interviewed, but I would say at least 10% to 15% of the people are getting the interview notices. And as Emily has pointed out that even though the gentleman is a Houston district office, he is actually getting the processed in Harlingen office. Last year in 2020, I think so it was 2019, the USCIS issued a circular that says that people can be called interviews at a location that is not in their district office. If the other district office is more free, they could take your case. So for example, if your district office in Houston, Harlingen is the one that is calling you, that's about 4 hours drive or so from here. People, they said they will be interviewing, which is a very, very good thing. I would welcome them. I mean, if I'm the immigrant, I'm getting my 485 interview, I have to wait for 1 year in Houston, and I have to drive 4 hours to Harlingen. Believe me, I will drive 4 hours to Harlingen. And I know you all belong to my class of people. You will understand these things much better. You are willing to go. That 4 hours extra, and the USCIS understood it, and they are processing it to different district offices that may not be your home district office. So it's good news, and you can find out at the USCIS office what is your district office. There is a web link there at the bottom. You can find it out, but not at this point of time. You don't have to be worried about it. unless you get an RFE from a district office, you don't have to worry about it. Emily, on the H1B cap though, we have noticed that they have selected less than last year. Do you mean that there is going to be another lottery, or do you mean that they anticipated, oh, this is a different administration, we're going to approve more than denials compared to the last year?
Yeah, definitely compared to last year. Last year they selected way extra number of petitions to meet the cap because they were expecting a lot of denials to happen based on the Trump administration and all of their policies. And even with all of those extra, we still had a second lottery. Now I'm sure COVID played a big role into that, but this time around we know that they selected way fewer to meet the cap. They still select more than the number of visas available because they know a certain number are going to be withdrawn or denied, or they won't actually file the petition. But the reason they selected fewer is because they're expecting fewer denials because of their changes in policies with the Biden administration. But there still could be some denials. There also may have been a number of kind of duplicate registrations where the individual is only supposed to be applying with one company. So we may still get a second lottery this time around. Of course, last year they did not announce it in advance. They just started sending emails saying you've got an update in your My USCIS account. And I think that happened in September, October. And we were able to file until about November 14th, if I recall. So we'll have to wait and see, but there is some possibility for a second round this year.
Emily, with regards to the student visa people, a lot of people are under the mistaken presumption that they do have a travel ban. As you know that if they are coming here for going to master students, going to the college in August, they can come in within 30 days of the college starts. And what are the restrictions on the OPTs and STEM extensions or visiting India, Emily?
Yeah, they did confirm that F1 student visa holders, for those subject to the COVID travel bans, like in India and the Schengen region, you are able to use your valid visa to return to the U.S. You are automatically granted an NIE. You don't have to approach the consulate to get approval to travel. And that does include those whose program has ended and are using their OPT. They did confirm that a few months ago because previously they did not specify on that. For those that don't have the visa and are starting new programs, the consulates do seem to be trying to prioritize you for emergency appointments because they understand classes are going to be starting in the fall right around the corner here. So they are trying to get everybody their student visa.
Emily, I want people to be aware that when they do EB2 to EB3 downgrade, there are some issues of the ability to pay. Particularly, I'm concerned with some of the people who left the company. Let's say, for example, my company has filed in 2015, April of 2015, a labor certification, got it approved in by 2016. I would say December of 2015, I got my I-140 approved, and I left the company in 2016. Now I want to go back. What is ability to pay? Why is it different for the people who are working with the company as compared to who left the company and are coming back right now?
Yeah.
Or who left the company and never coming back?
Anytime a company files an I-140 petition, they're required to demonstrate that they have the ability to pay the wage that was specified on the labor certification from the priority date going forward. So when that company back in 2015 received that perm labor certification approval and filed the I-140 petition, they submitted at that time documents showing they had the ability to pay. Usually that is in the form of the company's tax return, if they're a smaller company, less than 100 employees, along with the employee's W-2 and recent pay statements. If the company can show they're already paying that wage, then they've established ability to pay. That's why when you are filing an I-140 for a person who's working for the company that sponsored them, ability to pay is usually not an issue because the company's already paying. There's only an issue if they were paid less than the wage specified in the labor certification. Compare that to now we are going back and filing a downgrade. When we file that downgrade, we still have to show the company had the ability to pay, not from now, but all the way going back to 2015. So they may have ability to pay in 2015 because you worked there and they have their W-2. You have your W-2 from 2016, but then you left the company. 2017, 2018, 2019, and 2020, the company has to rely solely on the net income listed on their tax return. If that net income is below the wage requirement, they will likely get denied on the ability to pay issue. And even if that net income is more than the amount listed on the labor certification, if they've sponsored multiple people for these downgrades, they had several employees that left and are coming back to file the downgrade, USCIS adds up all the required wages of all of those employees, and their net income has to cover everybody, not just your individual petition. So anytime someone has left the company and is considering filing a downgrade with an old employer, there's a risk of a problem with ability to pay, and that downgrade might get denied.
So Emily, let's say prevailing wage is $100,000 and I'm making $100,000 in 2015. And you're telling that if the company has profits of $100,000 for each year, and let's say, for example, if they have 5 people like me, that means that their net income is more than $500,000, that may be relatively safe for them to get the I-140s approved. Isn't it good enough? My company is telling me that if I join them back itself, so let's say, for example, I'm going to join them in 2021 in July. Isn't it enough? Now I'm making more than $100,000.
No, it's very clear in the regulations that ability to pay has to be documented from the day of labor certification filing, from the priority date going forward. So just because you're being paid now, it does not cover those gap years. You have to show every single year that you were either paid or the company's net income is sufficient to meet that wage requirement.
We'll go to the Q&As. The question comes from Ram from YouTube. I've applied I-140 in April. If the date becomes current in October, can I convert into I-140 premium and apply the 485? Can I do it both at the same time? You can, but why can't you do it right now? Why do you want to keep waiting? If I were you, Ram, I would do it right now. I will not wait for the priority date to become current. Keep it ready. You have many advantages to have the I-140 approved, because if you do it at the same time, what happens if the I-140 gets denied? There are a lot of other advantages of getting the I-140 approval in advance.
Great question from Prashant from YouTube. My attorney told me that USCIS has a high rate of denying I-140 cases that you upgrade to premium because it normally takes more than 2 weeks to decide. And that fast tracking the I-140 does not have any bearing on how quickly the 485 gets approved. I completely disagree that premium processing in I-140 has a high rate of rejection. What causes an I-140 to be rejected or denied is not proper experience letters, lack of ability to pay, odd combination of education or an education evaluation that includes experience when it's not supposed to. Premium processing does not cause rejections. We've been upgrading all the downgrades from October into premium processing, getting approvals. Prior to this, we filed many I-140s in premium processing, upgrade to premium processing. We're not seeing denials on our premium processing cases. As far as, it doesn't really have any bearing on how quickly the 485 gets approved. That's true when the 485 processing time is longer. But if the 485 processing time is where the officer's ready to adjudicate and your I-140 is still pending, they cannot approve your 485. They have to sit on it. It goes on the bottom of the pile to wait until that I-140 is approved. So yes, having the I-140 still pending can delay your 485 approval, especially when the final action date is already current. The officer's hands are tied.
Are these coming from lawyers? Are these statements coming from the employers, Emily? Some of the employers want them to be bound by these kind of things, where if the I-140 is not approved, people like you and me are recommending not to change the job. Of course we did. So I think some of these things definitely are coming from the employer, not from the lawyer. That's the way I look into it, though. Prashant Kadapa from YouTube has, the previous priority date is a wrong I-140 in the I-140. Looks like the lawyer or something happened. It did not got ported into the previous one. Well, you can do one thing. You can correct it. That's one thing. And if there's the best way to do it, file it again, the I-140. You can definitely do it. I mean, that can be done. On a safety precaution, if the previous I-140 does not have the proper documentation, does not have the proper information in there for the downgrade, I would definitely refile the application. To be on the safer side, because right now the prior date is becoming current for most of the people, I would spend the money to refile the entire thing and make it ready. Question from Tech Sri from YouTube asks, my birth certificate affidavits, do they need to be on a stamp paper in India or a simple paper will do? Unfortunately, in India, the notarization can only happen on the stamp paper. Now, there are two kinds of stamp paper. The stamp paper, it starts from the stamp and goes down. There's also at the end, there is a stamp, they put it out. It's called notary stamp. They have to have that stamp in India. That's a law in India. I also happen to be a lawyer from India, though I didn't practice that much, but I'm still a licensed lawyer in India. You should get the stamp paper there.
Rishi from Facebook wants to know, can I use advanced parole to enter the US if I'm currently in India? Technically, yes, but only after you've quarantined in another country for 14 days because you are subject to the travel ban due to COVID right now. Ram from YouTube wants to know, does USCIS write down my H1B case number on the H4 and H4 EAD applications when they separate them, or should I expect an RFE on the H4 and H4 EAD for the H1B approval copy? I don't know whether they write it down, but I would say at least 75% of the cases USCIS is able to see that H1B has been approved, and they approve the H4 and H4 EAD when the processing time is up. I would say less than 25% of the time we sometimes will get an RFE for the H1B approval notice and proof that the H1B is continuing to maintain status, so we have to submit recent pay statements. There doesn't seem to be any rhyme or reason to which case gets that type of RFE.
A lot of questions are coming with regards to the downgrade application. If the downgrade application is pending, can I file the 485 application when the priority dates move? Yes, you can. Terence Biber from Facebook has this question. If the EB2, EB3 can the EB2 to EB3 downgrade and 485, can it be filed together when the priority date is current for filing? The answer is yes, you can. You can do that without any problem. Questions are with regards to if the EB2 I-140 is approved and EB3 downgrade is also approved. If the EB2 moves forward, even though EB2 was filed before, can you still use the EB2 approval to file the 485 application? The answer is yes, you can. You can do the 485 application at the same time, not a problem. Questions on 485 premium processing. Is there any premium processing for EAD, 485 EAD or 485? The answer is no. There is no premium processing for 485 or EAD at this point of time.
Sankar from YouTube wants to know, can I file an H1 transfer and then file the 485 in October while the transfer is still in process? I would say it depends, because if your I-94 has expired while your transfer is in process, that can be very risky because you have to continue to maintain your H1B status at the time of filing the 485. And if your transfer ultimately gets denied, it's as if you failed to maintain status going all the way back to when your I-94 expired. So definitely use premium processing and you won't be in that situation. You've got plenty of time to get that approval in time before filing the 485.
Shankar is planning to go back to his old employer and he wants to file a H1B transfer. While the H1B transfer is pending, if the priority date becomes current, can he file the 485 before the H1B is approved? Absolutely you can, no problem.
Harsh has an approved I-140 with Company A and a 2014 priority date, and he's with Company B, but they just started the green card process in April of 2021, and he wants to know, will I miss this boat? So partly depends on what exactly they started in April 2021. If they only submitted the prevailing wage request, then you may miss the boat in October, because it's taking 5 months just to get the prevailing wage, and then they'll start their recruitment efforts. That can take up to 6 months before they actually file the perm, and then the perm processing is another 5 months. Now, with the priority date of 2014, it all depends on where the final action date moves. If your priority date is current, the 2014 date, only under the filing date chart, we may be limited in how long we can use that filing date chart. Last year it was October, November, and December. If the final action date becomes current, that date should hopefully remain current to allow you to file the I-140 and 485 together once you get your perm approved.
A lot of people, especially those people who have not filed the 485 application, are predicting, oh, my priority date is this, my priority date is this. What should I do? What should I not do? One thing is for sure is that this is not a right time to change the employer, because if you change the employer, you may not be having good time in filing the 485 application. If I were you, if my priority date is before December 31st of 2018, I would like to file myself EB3. Then I will have option of EB2 and EB3. Both of those things are available. It's an investment, and this can be paid by the employee, doesn't have to be paid by the employer. If you request your employer, if you have both the things available, then you have a choice of filing an EB2 or EB3, especially if you have an EB2, which most people are predicting that EB3 is going to move forward more than EB3, at least in the month of October of 2021. I would definitely like to file my EB3 and have both the options ready though. If you want to use our services, there is at the bottom, there is a link. You can send an email to us and we'll give you the description, what we charge, what the information. But for any outside lawyer to represent your company, you definitely need to get the permission. You definitely need to get the permission from your employer. With regards to the big 5 consulting companies, at least the 2 top consulting companies from India though that are doing, we do file their 485 applications, even though we didn't represent them in the labor I-140. They are very good in giving them, the employees, which in turn they will give the 485J supplement to us and filing the 485. We offer this service so that all these things can be done right now. Come September, we definitely are not going to take any new cases, and most probably that will be the truth with most of other competent immigration lawyers. So it may be better time for you to speak with those lawyers and get that thing right now. We do offer a very not a discount rate, but very nominal amount right now, but we will charge the full amount when the priority date becomes current, and we're making all the applications ready, including the pictures. We'll make it ready come October. We just need your 485J supplement, which you can email it. We can insert it and file the 485 application. That's what we're doing. So if you want to avail our services, there is a link there. But if you may want to discuss with your lawyer, they may be offering that too. You may check with them and then have everything ready so that you are set to go in September. Just do what you can. Now, with regards to the priority date, how it's going to move, whether it's going to move, whether it's not going to move, it's going to be tough for people to predict though. Try to do the things that are in your hand and wait to see what is going to happen in September. Most people are predicting the priority dates are going to move because last year we had 130,000 extra green cards. The priority date moved 4 years. This time we are expected to have at a minimum of 150,000, if not more green cards that will be available. So we do expect the dates to move, but can we say it's going to be 4 years, 5 years? I don't think so. We're estimating at 4 years beyond 2015 for sure. But there are some people who are estimating even up to 4 or 5 years. We may not be estimating. So be prepared for you. That's all. As an immigrant, I advise you that you be prepared. That's all you can do.
Amit from YouTube wants to know how long it's taking for the 485 adjudication after fingerprints have been applied to my case. So the 485 processing time really isn't related to when the biometrics are done. It's related to what is the normal processing time according to the public information on the USCIS website. So if the location where your application is pending or the local office where it gets transferred to has a long processing time, it doesn't matter if you got your biometrics done earlier versus later. It doesn't really have much impact.
A lot of Ayan is asking the question, is there a 1-year limit of filing the 485 application? It's when the final action date becomes current. It's riddled with too many exceptions available. It has a lot of things that are exceptions available. So I would not flatly state that no, you cannot or you can. There are a lot of exceptions available if final action date becomes current for you to file the 485.
Rajendra from Facebook is working with his employer to talk about the EB3 downgrade for October, and the attorney is saying the role we would be using for your green card really does not fit within the EB3 category. Is that true? If you have an EB2 approval based on a labor certification, you should qualify for EB3. It has nothing to do with whether your job is above EB3. It's, do the requirements of the labor certification meet the requirements of EB3? You could have a PhD and be fine in EB3. USCIS doesn't care. All they care about is, does the labor certification meet the requirements of EB3? It's like saying, is a billionaire also a millionaire? Yes, absolutely. No difference.
Emily, can you explain the Schedule A physical therapist again, please? This question is coming from Ankabi Adigun.
Yes, so I've mentioned a couple of times that I filed some of those applications and they've been pending. I can tell you that from one of the service centers, they seem to be denying all of the Schedule A cases, and another service center seems to be approving them. Seems to be based on service center. What is the issue with Schedule A and downgrades? So Schedule A is a special provision where you do not require a labor certification from the Labor Department. You file a labor certification directly with USCIS, and USCIS determines, they certify that labor certification. In these denials, USCIS is saying that that USCIS certified labor certification cannot be used to file another I-140 petition, that you have to submit a new labor certification, new prevailing wage, new notice of filing, and then port the date. So that's what one of the service centers is saying. The other seems to be approving them after they send RFEs or notice of intent to deny. No rhyme or reason to it. We're looking into options of filing appeals or even litigating this, because it's completely arbitrary when two service centers give you the exact opposite results.
Karthik has a good question. His priority date is 2017. He really wants to change a job. Obviously, right now the IT market is very good. I know you may be getting $100,000 more or even more. I don't know. That's very lucrative. How long? Here is the thing, Karthik, that if I were you, if the priority date becomes current, which we are expecting for 2017, I may go wrong in it, but if the priority date becomes current, it's only a matter of 6 months. So after 6 months of filing the 485 application, you are a free bird. What if the priority date goes back? It doesn't matter. You can still go to a different job, file a 485J supplement. It's so simple. You don't need an client letter. You don't need vendor letter. And guess what the filing fee is to change from one employer to another employer? It is $0. And then what if you change to another employer and you want to move from one location to another location? Do you need to file a 485J supplement again? No. Absolutely not. Do you need to file any amendment? Absolutely not. You can keep on hopping around the companies, you can keep on hopping around the places. You don't have to file the amendment. It's only the matter of waiting for 6 months after filing the 485 application. I just want to make sure the people who are listening, their I-140 also should have been approved. So if the I-140 is just 6 months, 180 days you wait, you are a free bird. So if you file in September, April, you are a free bird to move, even if the priority dates go backlogged.
Eru from YouTube, his priority date is in 2016, and the company attorney is suggesting for the EB3 not to do a downgrade, but to amend the I-140 to EB3 and file the 485 along with it if it becomes current. I don't know where these attorneys are saying that you can only amend an I-140 and not downgrade an I-140. This came up in September, October when we were trying to get all of these applications ready for filing last year. It scared everybody because one attorney claimed they had a rejection of a downgrade. We've been filing downgrades for years. It's not a new concept.
Well, Emily, priority dates of EB3 only moved advance in October of 2020. How did you, we've been doing all this for years?
Yeah, for India, that may be the case, but for China, the dates have flip-flopped back and forth again and again, and we've filed upgrades and downgrades going both directions over the years. So I've never had a downgrade denied or rejected because it wasn't filed as an amendment. There's no reason to file this as an amendment. On top of that, if you do file it as an amendment, you're eliminating your EB2 and turning it into EB3. If you file it as a downgrade, a new petition, you have both EB2 and EB3 and can proceed with whichever happens to be better for you from a timing standpoint.
Question from Akshay. Any update on AZTEC and Integra investigation? For those people who don't know what this is that the US, the ICE has published in the website the employers that are using the OPT and STEM extension. And the company called Integra, and you can look into my website on that, happens to be the #2 employer using the OPT and STEM extension. And that particular company, the #2 only to Amazon. AZTEC seems to be #5 and #6. Both these companies have the same address, same person operating. So both of these combined companies are actually the #1 employer of the OPT and STEM extension, more than Facebook, Google, Amazon. They are the #1 company in employing AZTEC. The investigation of the USCIS or ICE found out that they are in the company, nobody out of the 4,700 people who got their OPTs and STEM extensions, not just OPTs that got their employer letters, not a single person has ever visited that office, not a single person has ever worked for them in their office location, not a single person has ever physically met any of the officials of the AZTEC and Integra and shook hands with them. And later on, our investigation find out that these people were operating from India, and seems that most of the people, if not all the people, have paid anywhere between $250 to $2,000 to issue the OPT letters. Some of them even got their 983 signed by them when they applied for the STEM extension. So these people either have got some of these people got emails from the US consulate if their student visa is still valid, saying that their visa has been cancelled. Some of the people, when they were entering into United States, were being sent back. Some of the people, when they were going to India, they were being stopped at the airports, were being told not to come back because they cancelled their visas and told them not to come back. Some of the people, when they are applying for the visa, they got their visa denied because they work. According to the law, if a person uses any illegal or fraudulent means in obtaining the employment authorization or continuing to use the employment authorization by the USCIS, it is considered to be a fraudulent activity, and they cannot come into this country unless they apply for the waiver. The waivers are very limited, very strict, very narrowly defined. So if any persons have worked with AZTEC or Integra, please make sure that these names, I'm pronouncing it, but if you want to check, please go to rnlawgroup.com. I will try to put a link and the articles that I have written on this particular two companies. Don't get me scared, especially there are some good companies with the same company name called Integra. There's a little bit variation on the company name, so I don't want you to get misguided on the good companies of Integra but the bad company of Integra. I'll put a link out to you there in the YouTube and Facebook, guys, so that you can take a look into these companies. If any of you are friends, they should contact a lawyer immediately. I strongly advise that they should leave the country because they're getting thrown out. In some of the people, when they're filing the STEM extensions, are getting denied. Some of the people, when they're applying for the H1B change of status, they're getting denied because they work for these companies. So if any of the people work for these companies, please contact a lawyer immediately before you do anything.
Let's see. Ramesh from YouTube has a 485 pending, and he knows USCIS sent him a biometrics letter due to the online case status, but he's never received the letter. So he chatted with Emma, and she told him that he's scheduled for June 30th, but he still doesn't have the letter. He's got a call scheduled with a Tier 2 officer. And if you have dealt with a Tier 2 officer, that means that they take 2 weeks to give you a call back, and you may miss the call because you don't know when it's going to happen. So my recommendation would be for someone in that situation is go on June 30th and talk to them, and it's very possible they may take you as a walk-in. I had a number of people that had their appointments canceled last week due to the Juneteenth federal holiday that went earlier this week just to see if they could get it done, and they were able to get it done as a walk-in rather than waiting for USCIS to reschedule. So they may be able to do it without you having the letter.
Emily, I need your attention on this question from Pritesh Shah. His priority date is August 4, 2011 under EB2. Most probably he didn't file the 485 application. Does it make sense to file the EB3 downgrade? As you know, the final action dates for EB2 is June 2011, and the filing dates is somewhere in December, end of the 2011.
Mm-hmm. I would expect that your final action date in EB2 should be current in October, so it may be.
I think so.
Necessary.
It will be in August. I'm
Yeah.
expecting. I'm expecting. I'm thinking I will not do it,
Yeah.
but I will evaluate each month to see how the things were going. If by any chance if they go south, then I will. For example, we come to know about July in June. So if you come to know advance, and then I would file the downgrade if things don't go accordingly. But if I were you, I would be watching very closely and see how the things go in August. Yeah, that's why I'll be watching. And yeah, you still have until October to decide. Yeah, I may not, I'm choosing not to go for him.
Let's see. Swaroop from Facebook. As a third country national, can I get my first time H1B stamped in Canada or the Bahamas, for example? Prior to COVID, yes. Other countries were accepting first-time H1B stamp, especially if you have a U.S. degree, U.S. master's degree, for example, and you filed in the CAP and got your approval. But right now with COVID, most of the consulates are only providing emergency services and are not entertaining third country nationals.
Well, if anybody got the green card, please announce it. Guys, there you go. Mansa Devi from YouTube has her green card approved 2 weeks ago. But 485J is still not approved. Is that going to cause any problem? Absolutely not. Your 485 is approved. You're good to go. It's a little bit confusing. A lot of people some people get the 485J receipt notices. Some people get the 485J approval. Some of the people don't. But you're absolutely in good shape. You are a green card holder. You don't have any problem. You can be a Microsoft CEO. You can flip a burger in McDonald's if you want to, or you can become a lawyer like Emily.
Mm-hmm. Espoir from YouTube has a question about cross-chargeability. Spouses from Canada with a priority date of October 2019 and filed the 485 back in November, but no feedback on the case. How do we know if the cross-chargeability is accepted? So typically in a cross-chargeability situation, one spouse priority date is not current and the other spouse priority date is current. So when you file the 485 under the other spouse's country of birth, if USCIS issues a receipt notice, that confirms they've accepted the cross-chargeability because they're allowing you to file under the other spouse's priority date country of birth. But if you're saying that you filed in November and still don't have receipt notices, something doesn't seem right there.
I just want to explain people what a cross-chargeability is. This comes to picture when people, like for example, if the spouse is from China and you are from India. Let's take another example. Sorry, that's not a good example. Your spouse is from Philippines and you are from India, and she's born in Philippines and you're from India. You know the India date is backlogged, but you can use your wife's country of birth and then file the 485 application based on Philippines instead of yours. That's called cross-country chargeability. I also want to note that especially there are a lot of Indians who are born in Middle East and they never get the citizenship of Saudi Arabia or UAE, Qatar, or whatever those countries are. The USCIS considers country of birth as the country for getting the green card though. So if you're born in Qatar or UAE or Saudi Arabia, even if you never got your citizenship there, for the purpose of the green card, you will be considered to be from that particular country, and you can file the 485. Or even if you're a spouse and your main applicant is from India, whose I-140 is approved, you can be also cross-chargeable. So if a person who is born in UAE, their spouse is from India, even if the UAE person never had the UAE citizenship, they can still file under the cross-chargeability. Whenever we do the cross-chargeability, we put a big sheet. Do not reject in the mail room. That's what we keep it, because they see the Indian, oh, main applicant Indian, priority date is not current, they'll throw it out. So we put a big thing there, don't do it, and we put in a color sheet, and that helps them out so that when the officer is looking into it, do not reject in the mailroom, he gets an attention. Why is this lawyer expecting it to be rejected in the mailroom? Because we know these kind of things might be getting rejected. You may be careful. So if you write that, you have a good chance of not getting rejected. If you file in October, that's too far, Emily, for getting. I would refile the application, or something might have happened, rather than wait, because checks only expire in 6 months too, so that's another problem too.
Mm-hmm. Rama from YouTube wants to know, what happens to my approved EB2 I-140 if my downgrade petition gets denied because of ability to pay? This is a very risky situation, because any I-140, the company has to demonstrate ability to pay from the labor filing all the way until you get the green card, not just at the time of I-140 approval. So if your downgrade is getting denied due to ability to pay, USCIS could question whether the EB2 is still valid if the company doesn't have ability to pay there. That's a very dangerous situation. So if you have an I-140 downgrade ability to pay issue, like you've already filed the downgrade and now you got an RFE or a notice of intent to deny, and your attorney thinks that maybe their ability to pay is not there, you may be better off withdrawing the downgrade and proceeding only with the EB2 case. So that way you're saving the EB2 rather than ending up with 2 denials and no I-140 at all.
The ability to pay is more like a mathematical calculation though. So the lawyers would be able to determine very clearly if it's an approval or not. And especially in our office, we have a gentleman by name Ryan Vick. That guy can smell it from a mile. If you get an RFE from it, I definitely would recommend to consult him. He does I-140s he just, I don't know, he just breathes, he just eats, breathes, and sleeps in I-140. So that guy is very good. Don't consult Emily or me. Yeah, he's much better than us, both of us in there. Emily, I have this question that I want your attention. Junaid Elahi has this question. Can the final action dates can retrogress as well? I have seen the final action dates getting retrogress very many times before 2015, Emily, because we never had filing dates and final action dates before. I mean, before October 2015, we never had it. So yes, final action dates were retrogressing very many times. Did you see the same thing after the filing dates and final action dates came in 2015?
No, we haven't, and that's the entire reason why they created this separate filing dates chart, is to avoid the whiplash of going back and forth with those dates. And so they can manipulate the filing date chart. USCIS can turn it on and turn it off from one month to the next. So if they start getting too many 485 applications in 1 month, the next month they can say, nope, you can't use the filing date chart anymore. That is what allows the final action date chart to not retrogress. Is it impossible for it to retrogress? No, it could happen, but that was the #1 reason why they created the filing date chart, was to eliminate retrogression in the final action date chart.
So if you go to the history though, definitely there were 1,000 times that it went back, but starting from 2015, it's completely different story. And that's the reason we are pretty confident that the final action dates will not go back. And this question was raised to Charlie of State Department, and he said that at least until October of 2022, the final action dates are not supposed to be back, going back. That's what he said. So I just want you to be aware of that.
I have a question for you. This came from PK. I lost it on my screen here, but he was asking, can you explain the spill down and spill over between EB2 and EB3? If there are extra EB3s, will they move up to EB2? Is that how it works?
So let's understand this. I compare this like a buffet, okay? Now, there's 40,000 for EB1, 40,000 for EB2, 40,000 for EB3, and rest of all the categories will get 20,000. So, and the excess green cards will be going in the same proportion, 28%, 28%, and 28%. So they all will go into EB1. If the EB1, the buffet, they invite all the people who have an I-140 approved to come and eat. And if there is nobody there, the EB1 will fall into EB2. Now they will invite all the people whose EB2 priority date is earlier. For non-Indians, of course, they get much more priority. After the non-Indians and non-Chinese eat the whole buffet, the leftovers of the rest of the world, the leftovers of the food, Indians and Chinese will get 7% each. And the leftover food will be given to the people who have been standing in line for a long period of time, which happens to be mostly only Indians. So then those people will be given the leftovers of them. Now, if there is anything left over from EB2, it will go to EB3, but we are not expecting, remember, there are too many people waiting for there, so we're not expecting anything to go down from EB2 to EB3. Do you expect that, Emily?
No, I agree with you. How do these extra 150,000 green cards come into play?
They will come into the same proportion, 28% if I'm not mistaken. So approximately around 42 to 43%, 43,000 will go into, out of the 150,000, 43,000 will go into EB1. There are already 40,000, so extra 40,000. So that's 83,000 will go into EB1. And the same thing, 83,000 will go to, the total 40 plus 43 is 83,000 to EB2 and 83,000 to EB3. If most probably EB1, we won't be getting used all 83,000. So let's say if 40,000 are used, the rest of the 43,000 will fall into EB2. So that will be 83,000 plus 40,000. Now this 40,000 is an estimate though. I can't tell you certain how many it's going to be. So 83 plus 40,000 is 123,000 will be falling into EB2. If by any chance they're unable to use that, it may fall into EB3, but we are not expecting any spillover going from EB2 to EB3. Remember, the priority date is much backlog for EB2, so most probably nothing will get spillover. Then for EB3, it's going to be 83,000, 40,000 existing every year, plus the 43,000 due to the COVID that we got the extra green cards. The 83,000 will be going to EB3. You may ask a question, when these spillovers are coming from EB1 to EB2, how come the EB3 date is moving forward though? When you look into the stats of the USCIS, how many I-140s were being approved though? It looks staggeringly that most people got their I-140s approved in EB2. Especially in the past 4 or 5 years, it's about 90% of them were approved under EB2 and only 10% got approved under EB3. So that's the reason why the demand is a little bit lesser. Even though EB2 gets more number, EB3 is moving forward. Now, is it an assurance that all the time EB3 is going to move forward for Indian nationals? No, maybe not. I mean, sometimes things may switch. So if you go and observe how the Chinese people work out, sometimes EB2 goes forward, sometimes EB3 goes forward. I don't know. There are some clients, Chinese clients that I have, oh my goodness, we have to change lanes so much. I believe in the same thing that when I go to LA to visit my son, the lane that I go always stops. And then guess what? After 2-3 minutes, I get this headache and then I move to the next lane. Guess what? As soon as I move to the other line, boom, the lane that I moved from moves, the lane I am not doesn't move. So sometimes it may be advisable just sit in the same lane and go instead of keep changing every time. What is more important is for you guys to be in the 485 application. That's very important at this point of time. Once you're there, you can always make a decision to move to EB2. If you have both EB2 and EB3 approved, you can do interfiling and you can change if you want to, but I would use the interfiling judiciously, not just take the emotional thing, hey, this month it moved, let me do it. Don't do it very judiciously.
One last question here. Pathuri from YouTube wants to know, is the date of filing or the final action date considered to determine the age of the child at 21 for issuing the green card? So for the Child Status Protection Act to take effect, it's when the final action date becomes current. So if you've already filed the 485 based on the filing date chart, that does not lock in your child's age. They will continue to age while that 485 is pending until the final action date becomes current. Then you'll take the age on the first day of the month that the final action date was current. If they're already over 21 at that point, then you look at how long was my I-140 pending, subtract that amount of time from that age that you calculated. If that brings it back under 21, then the age is locked in and they can receive the green card with the rest of the family. We do have a video on the Child Status Protection Act just on that topic, so you may want to check that out.
Suggestion. Why isn't Charlie out on the YouTube last week? Well, he's supposed to come in. It was a holiday declared. Suddenly, he didn't show up, but not much is expected from him. He's already predicted what he's going to do it until September of 2020. He already predicted what he's going to do. He already gave an estimate how it's going to move in July, August in family immigration and also in business immigration. So maybe he thought that it may not be needed to come again and give the same redundant information. I don't know. Maybe he'll come up because the Friday, this Friday, yeah, it was a federal holiday. There was declared in like 3-4 days before. Maybe he'll come up in this week. He may come up in this week or maybe next week, and predicting the August and going forward, he may predict some better things. But I'm thinking that don't expect any surprises to come from him.
All right, well, I think we're out of time for today. Thank you for joining us. Remember, you can always set up a consultation with us or any of us, our attorneys here at Reddy Neumann by going to rnlawgroup.com.
Thank you.